All right. We are on the record in 231-500-139, State of Utah versus Kouri Richins. Can I have counsel for the state make their appearances?
Good morning, Your Honor. Brad Bloodworth, Lindsay Shervanack, Margaret Olson, Joseph Hill, and Fred Burmester for the state.
Welcome to all of you. For the defense, please.
Wendy Lewis, Catherine Nestor, and Alexander Ramos, and Ms. Richins is present.
Good morning, Ms. Richins. All right, we're here for an evidentiary hearing on 3 motions to suppress. We previously had a discussion on the record regarding initial burdens. I've made notes on the motions that match that discussion. Which motion do you all want to handle first, or is there an agreed order of events?
Your Honor, there's an agreed order that roughly follows chronology. The first is the motion to suppress statements and evidence. The state, for 3 of the 4 issues raised in that motion, bears the burden, so we've agreed that the state will just go first on that. The second motion is the motion to suppress electronic data. The defense bears the burden on that motion. The defense will go first on that. The third in order is the motion to suppress the letter. Again, the defense bears the burden. They will go first.
Who is the state's first witness?
Your Honor, the state's first witness is Detective Eric Maynard. But before we get there, the state would like to move into evidence what we have previously marked as exhibits 1 through 149. Move into evidence for the purpose of this hearing only.
Is there a stipulation to that effect?
Your Honor, we got these exhibits at like 10:30 last night. I was already asleep. So can we just do that at the end? I mean, whatever he ends up using. I don't expect we're going to object to any of these, but just because I haven't gone through them all, can we just they come?
It would be helpful to me to have a record of what's being offered through which witness so I can understand and have some notes. Any objection?
Your Honor, in a sense, the state is offering them into evidence now, kind of considering both the evidentiary standard for a hearing like this,
right,
under 1101 referring back to 104. The state does not intend to address most of these exhibits today. Rather than the state is moving them into evidence to use them to reference in our follow-on papers.
I appreciate that. Are you going to be laying any foundation for the ones you don't expressly reference today? For example, there are, it appears, numerous either transcripts or notes from telephone calls. Is somebody going to talk about where those came from or when they were secured?
Your Honor, we can. All the phone calls referenced are jail phone calls using HomeWave, the jail phone call system, which, I don't know, we have laid foundation for several times throughout the course of the proceedings.
Right.
I think kind of the only, to my mind, audio and video recordings that we haven't discussed in other proceedings in some fashion are a video recording by Detective Maynard, an audio recording by Detective Woody, and a video recording by Detective O'Driscoll. I will address each of those recordings in my examination of those witnesses.
I appreciate all of that. Guess it's up to the state to proceed how you want, but I'd hate to see you miss a short opportunity to lay some basic foundation for some things that you want to refer to in the briefing rather than just call a witness who can say this is how this stuff was gathered. You need to provide some foundation for reliability. It doesn't need to meet the formal admissibility threshold that would be required under a formal application of the rules of evidence. But there has to be some foundation for reliability.
Yeah, I appreciate that, and I guess to some edge we can do that. I think mostly we're talking about warrants, self-authenticating documents.
Sure.
I'll bear that in mind.
Okay.
I appreciate that the defense didn't get notice of these exhibits until after I was in bed last night.
Sure.
Also, please bear in mind that the defense's moving papers are somewhat vague and uncertain. And rather than litigate their sufficiency under Rule 12, the state has decided, perhaps at some risk, but the state has decided to just roll with this. And in doing that, it is unclear precisely what evidence we will need to respond to the defense's motions, because at this point I don't think we're really on proper notice. So we have taken an expansive view with the hope that we have swept up all the evidence we may need. That, of course, will be ultimately determined once we receive more substantive papers from the defense.
We'll see where this goes. The defense certainly is reserving its objections based on or regarding the reliability of the state's evidence, and we'll see how it shakes out. Okay. With that, go ahead.
One more, Your Honor.
Yeah.
Not only is there 1 through 149, as we have done in the litigation so far, there are certain documents on the court's docket that we will be referring to throughout today. For example, 214 is the walk the dog letter.
Understood.
And we will refer to in our opposition papers.
Okay. Understood.
Your Honor, subject to the off-the-record discussion this morning, the state calls Detective Eric Maynard.
Okay. I'm going to adjust that a little bit. On the record, but sealed discussion we had this morning. Sam, I need you to stop video recording for a moment. Thank you. There will still be an audio record of Detective Maynard's testimony. Ms. Nestor, you're looking at me. You ready to go? Okay. Let's call Detective Maynard. Zach, will you let Detective Maynard know we can have him in now? Thank you.
Yeah. I don't like them this way.
Sam, to be clear, audio fine, no video for this witness. Thank you, sir.
And Your Honor, just to be clear, we're only objecting to the video of the witness himself.
Yeah, it's just easier to leave the camera
Okay.
off.